All right, hello there. Welcome. Another edition of the Employment Law Show has arrived. Good to have you along. John Scholes here. Beside me, Lior Samfiru, of course, employment lawyer. Reach out to Lior anytime. It could be a chat. It could be something you need him desperately for. But the contact remains the same, 1-855-821-5900. Back it up with an email, help@employmentlawyer.ca. We'll give you more contact and more useful websites as the show rolls on over the course of the next 30 minutes or so. We always have a main topic. Lior, I love this one this week. Social media and your workplace, what you should know. Hugely important topic, pretty much for everybody who's got a cell phone or a desktop or otherwise. We got to talk about this, and we'll do it in just a bit. We'll get to some phone calls from one of our radio shows across the country. Again, employmentlawyer.ca to find a radio station that carries our show near you. And in most cases, most shows, you have the opportunity to call in and ask your questions. That's what we're going to do with those phone calls, which we will hear in our ear in just a bit. That's all ahead, Lior, but we always start off with the week that was, pal. What do you got cooking this week?
Hey, John, great to be here to join our good viewers and talk about this very, very important topic. I know you have a job. I know you work. And if you work, you have rights. But sometimes you also have problems. There's issues that affect your job. It's not always going to be positive. Sometimes negative things creep into our work life. Well, the good news is the law's still there to help. The law is there to provide solutions and rights, and in some situations, get you out of a bad work environment, okay? That's one of the things the law can do for you. It tells you that you don't have to put up with harassment, with bullying, with a poison work environment. There's options to either get that corrected or to get you out of there with your full compensation. And on this show, we talk about these things and many other things like wrongful dismissal, constructive dismissal, human rights violation. All those things may affect your job, and all of those things are under the rubric of employment law. So if you always wanted to know your rights, you wanted to get the right information, not something that someone posted on Google, you need the right information. This is the time. This is the show. But again, this is 30 minutes, so we can only get to so much. But I'm not going anywhere at the end of the 30 minutes. You can reach me in the office by phone or email. We'll give you that contact information throughout the show. But let's start off with the situation that came across my desk very, very recently. I spoke with the gentleman who had been working for the same company for about 6 years, and he always had a company vehicle. And recently, the company decided, well, we don't need to have that vehicle. You should be able to get to work on your own, and we're going to take away the vehicle. Well, this person, okay, lived quite far and needed that vehicle to get to work. And in fact, he had told me that it's a type of job he never would have taken, he never would have done if he didn't have a company vehicle, didn't have another car. He lived in a remote area. And for him not to have the vehicle means he either has to buy a car or try to get there by public transit, which would take hours and cost a lot of money. So for him, it was a very, very big deal. So he talked to his employer, he tried to convince them, and tried to explain to them, and they said, too bad, that's on you. Finally, he called me and he wanted to understand his rights. Now, here's the thing. For most people, taking away a company vehicle may not necessarily be something that you can do much about. But for him, it was huge. He literally couldn't continue doing this job. So because of that, the fact that they took the vehicle for him is a constructive dismissal. It's a major change to the terms of employment. So he now can treat this as a termination and get his full severance. So it's an important reminder that if a company does something to you that maybe seems minor, but can have a major effect on you, that could absolutely be a constructive dismissal. It may not have had a major effect on anyone else, but if it's impacting you in a significant way, it's going to cost you a lot more money. It's going to create a very difficult way for you to get to work, etc. If it's impacting you significantly, it's potentially not legal. It could potentially be a constructive dismissal. So you really want to speak to me if something like that happens to you.
You know, the first question that kind of comes to mind, Lior, is, with this severance that he is now owed because of the constructive dismissal, do they have to factor in the dollar amount of that rental car for the duration of the severance?
John, it's almost like we've been doing this show for a while, but yeah.
A couple times.
A couple times. Absolutely. Why?
Yeah.
Because having that car was part of the terms of employment, part of his compensation. So if the value of a car, I don't know, is $500 a month, let's say that's what it would cost him to rent or lease a car, well, that has to be accounted for as part of his severance, okay? The value of the company vehicle, or if there's a car allowance, that all has to be included as part of your severance. It's all components of your compensation, not just your salary, benefits, bonus, car, pension, bonuses that have to do with stocks. All of those have to be included as part of your severance.
How far does this go? And I guess in some terms, we're really speaking to people, it could be everybody, but a lot of people in the sales position. If they take away your company laptop, your company cell phone, all that stuff, maybe a per diem for lunch, I don't know what else. Does that all have to be factored in as well?
Yeah, generally speaking, anything that you get as a perk has to be included. Now, if you were able to expense your, I don't know, your toll highway expenses on the way to work, that may not be something that you will get as part of your severance, because if you're not working, you're not going to incur those toll charges. But if it's a perk, if, for example, if the idea was no matter when you incur those toll charges, even if you're on the weekend going with your friends out, we'll pay for that, then it becomes a perk, and that would then have to be included as part of severance.
Because I find this so interesting, let me ask you one more question, Lior. It kind of came up to mind before we move on to a phone call. In the case of, say, a landlord or a superintendent of a condo building, they get let go. Generally, they don't pay rent because part of their compensation is that apartment. What happens in that case?
John, I've spoken with many superintendents over the years that they've been let go and they're being told you got to evacuate the apartment right away. Well, not so fast, because that apartment that they get for little or no money is part of their compensation. So the value of that has to be factored in as part of the severance. So yes, if part of your compensation is you get a free apartment or a cheap apartment to live in, that value is your compensation. It has to be accounted for the severance period. And I felt many superintendents in that exact situation get that value of the apartment.
Okay, as I mentioned, employmentlawyer.ca to tune into a radio station in your community to catch our show during the week. Let's get to our first phone call from the show, Lior, one of our shows anyway. Here it comes.
I'm calling on behalf of my daughter-in-law. Yesterday, she was advised that her job has been eliminated. So she wants to know if the severance they're offering her is sufficient or is what she is entitled to. It's been 2 years with the company, 37 years old. Her annual salary is about $70,000. And you want to know what her position was?
Go ahead.
Event project coordinator.
Jay, break it down. What do you think?
So obviously the issue here likely is simply severance. It's not even about why she's been let go. And in most cases, we want to understand, it's important we understand that if your company is letting you go, it's not about that, the fact that they let you go. Whether we like the reason, agree with the reason, or maybe there's no reason, in most cases, they're allowed to do that, but they have to pay you your full severance. And where a wrongful dismissal factors in is when you're let go and are not paid your proper severance. That's what happens in 90% of the cases. So our job is then to figure out, what does she get for severance after being let go? Well, I can tell you, but I can also show you how you find out for yourself. So we're going to go to pocketemploymentlawyer.ca, and we're going to use our severance calculator tool. We're going to plug in the information, and let's see what that gives us. So 37-year-old project coordinator, been there for 2 years. Severance for her would easily be 3 months. And John, that's conservative. It could even be as much as 5 or 6 months, okay? So that's what severance looks like for this person, even after only 2 years of employment. That's why it's so easy also to use pocketemploymentlawyer.ca, use the calculator there. You'll be surprised by what you get, and never, ever sign off on that severance letter without doing that first.
And again, another example where most people on the street would think, oh, 2 years? Okay, she gets 2 weeks severance, maybe 4 if she works for a good company, right?
Yes, so not 2 weeks, not 4 weeks, easily 3 months, and potentially much more than that even. It's not a week per year or 2 weeks per year. In fact, short service employees with 5 years seniority or less, are treated disproportionately better than longer service employees. And in some cases, the length of severance can exceed the length of employment. So if that's not going to give you enough of a reason to call me or to use the severance calculator, man, nothing ever will.
Okay, phone call number 2 is coming up right now. Lior, let's listen into this one again.
Calling in for a friend. She got a letter, a performance letter saying that she's not doing, up to par, and she's kind of worried about losing her job. She was going through a rough time emotionally, so she agrees with at least part of the letter. So she's worried about losing her job, and she's just not sure what the next step should be on her part.
All right, walk us through it, pal. What do you think?
So it's a good thing and the correct thing to be concerned about, because oftentimes that negative performance letter is a step that the company is taking towards a termination for cause. They're building up a case to potentially let the employee go for cause. So the worst thing that you can do if you get a negative performance letter is to just be silent, kind of put your head down and hope that it all goes away, because that silence will be held against you. That silence is the same as accepting. It's like you're saying, yes, this is all right, I was all wrong. Well, that's going to be held against you if the company wants to let you go for cause down the road. So what does she do? She responds to it in writing. She tells her employer in writing, here's what you don't know, or here's what I disagree with. And if there's medical issues that had impacted performance, say so. Because to try to let someone go in the face of a medical issue, that could also be a human rights violation. So you're protecting your job. So I want her to respond, give all the right information in a respectful way, not in an accusatory way. And just by sending that email, that response, she's protecting her job. She's going to make it that much harder for the company to even consider letting her go for cause. So do that. And man, if she's let go still, she's got to call me right away.
All right, Leo, we're going to take our short break, and when we come back, our third phone call, then our main topic for the day, one we love, social media and the workplace, what you need to know, that is on the other side. So stay tuned, lots more of the Employment Law Show is coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Employment Law Show. John Scholes here beside me, employment lawyer, of course. Lior Samfiru, always reachable by phone, email, otherwise, 1-855-821-5900. It is help at employmentlawyer.ca. And beyond that, simply go to employmentlawyer.ca or pocketemploymentlawyer.ca, the only website you need. All right, let's continue on here, Lior. Phone call number 3 from one of our radio shows. Listen up, pal, here it comes.
Being with the employer for a long time, the company's changed hands a couple years ago. So recently, I was off work for a period of time. I had an injury. While I was off, I was presented with an employment contract, which had a bunch of troublesome stuff in it. A bunch of changes. I was basically told that, no, that's just the way it's going to be. How long can I wait before I say I was constructively dismissed?
A lot of red flags coming up here. What do you think?
Yeah, so listen, anytime you're presented with a new employment agreement, but certainly almost any time, that's not going to be good news. You'd much rather have worked without ever signing an employment agreement or a handshake deal. Those are much better than signing a 10-page document with a lot of legalese, because I can guarantee you that in that 10-page document, there's going to be tons of issues that are not favorable. So he's already noticed that in that new employment agreement, there's unfavorable things, there's changes to his job, etc. There's potentially many other things that are unfavorable. But guess what? It's not necessarily a constructive dismissal. He doesn't have to sign it. If he doesn't sign it, what's going to happen? Well, his company either backs off and leaves him be, or maybe they let him go, but in which case it's a regular dismissal with severance. Or maybe they say, well, I don't need you to sign. We're just going to implement these changes. And then it could absolutely be a constructive dismissal. The key is this, though. Do not sign anything without understanding exactly what you're signing and potentially what you're giving up. If your employer is asking you to sign a new employment agreement, whether you've worked there for a month or for a year, or maybe it's a sale of a business and you're asked to sign an agreement, please be smart. Do not do so without speaking to me first. That document could literally cost you tens of thousands of dollars, maybe even hundreds of thousands of dollars. You could be giving up future severance and many other things. So be smart about it. Let me see it first.
All right, let's get into our main topic for the show. Lior, been waiting to do this one. It's always a good one. It affects all of us, and that is social media and your workplace, what you should know, what you need to know. What you post online, first of all, even outside of work hours, can affect your job. How so?
Yeah, and too many people believe that, well, if I'm on my own social media account off hours, what I do is my business. No one can tell me what to do. Well, no, that's not necessarily true. If you post something on social media off hours on your own account and it can impact your employer, then yeah, it could affect your job. So if you go off on social media and you post things that can make your employer look bad, or maybe it's something that's going to impact your employees, maybe you post racist or misogynistic comments, your coworker can see that, that's going to impact them and therefore your job. And you can't say, oh, well, I just did that on my own time. So no, your social media and what you post can impact your job in a negative way, and it's not something you can ignore. Too many people believe, well, no one's even going to see it. I have my privacy settings on. Don't. If you post something online, assume, number one, that everyone can see that, and number two, assume that it's going to be there forever, even if you try to delete it. And if you're okay with everyone seeing it, and if you're okay that it stays there forever, then okay, you're probably fine. If you're not okay with that, it probably means you shouldn't post it. At least you should understand that it could impact your job. So yes, the fact that it's on your own time does not give you carte blanche to do what you want, and does not mean that your job is not going to be affected.
Point number two is this, Lior. Workplace harassment includes bullying or misconduct on social media. Most people don't think it extends that far, do they?
So an employer has an obligation to protect employees from workplace bullying and harassment, and that includes that type of harassment and bullying that happens on social media. So if you're an employee that's being harassed by your colleagues on social media through their postings on Facebook or LinkedIn, that is a form of harassment. You have to tell your employer, and your employer must deal with that. They can't ignore that. Same thing applies in reverse. You certainly should not be picking on a coworker or a colleague if it's on social media. The fact that it happened outside of the workplace does not protect you in that regard. So social media, especially these days when we spend so much time on there, is something that can result in workplace bullying. And if you're an employer, if you know that something inappropriate is happening on social media, one of your employees is not being treated properly, you can't ignore that. You have to deal with it. You have to investigate it, fix that issue. It's not the situation where you say it's off hours, so it's not my problem. If it's your employees, it's your problem.
What we're talking about this week, just to go over it again, social media and your workplace, what you need to know. Number three, Lior, employers now, we're flipping over to employers. They should have clear written social media policies and set expectations. And you got to make it, so people can read them and know about them, right?
Yeah, absolutely. So a lot of employers want to control and dictate what happens with use of social media in the workplace while you're working. And that's okay, but you have to have policies in that respect. You can't just tell an employee, well, we never told you, but we found out that you were on social media for a bit today, and that's not acceptable. No. If it's not acceptable, if you want something, if it's going to be something that you want the employee to avoid doing, have a policy, a written policy, and make sure that that policy is disseminated, that people know about it and read it. Only then can you enforce it. It's very difficult for an employer to complain that the employee did something wrong if that employee was never told they're doing something wrong. So have a policy about what's acceptable and what's not acceptable. And if you're an employee and you're being disciplined for breaching a policy that you didn't even know existed, that may be wrong, and you have to call me.
Our last point here may be a little bit confusing for some people, Lior. I know you're going to break it down nicely, but social media conduct can result in discipline or termination, but severance is often still owed. How does that work out?
So I started off the discussion by saying that what you do on your social media can impact your job. And, if you post something that makes your employer look bad, or you do something that's negative, if it impacts your job, there could be consequences. But the fact that there's consequences does not mean that you're deserving of the worst penalty, of the capital punishment of the employment relationship. It does not mean that you can be fired for cause without any severance. It's not enough for your employer to show that you did something wrong. For you to be deprived of your severance, it would have to be something pretty awful, pretty nasty that just makes it impossible to continue employing you. So maybe you posted something on social media you shouldn't have. Maybe you were kind of making fun of your boss, and that's not good. The boss found out about it. That does not mean that that alone gives the company the right to fire you for cause. If they still want you gone, they're going to have to pay you your full severance. So anytime the company is trying to deprive you of severance, remember, that may well be a wrongful dismissal. You need to call me so we can discuss the particulars.
Let's take one more short break, and on the other side, we'll get to our live stream social media. Anyway, we'll get to a question from the live stream, so stick around that. Maybe some more email questions. We got time, so we're going to take a short break, come back with lots more of the Employment Law Show. So stick around. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Lots more to go here. We're going to get to a question from your live stream. By the way, the live stream happens on YouTube, Facebook, LinkedIn as well with Lior and a bunch of other lawyers of the firm. Really super informative and an opportunity for you to ask questions. Want to join in? Go to @STLawyers, @STLawyers to do so. Okay, Lior, here's the question. I worked in a technical role for a company for 5 years and was just let go. They considered me to be a contractor, but they were my main employer. I worked full-time hours, had my own office, and used their computer and phone. I did a small amount of side work, but this was my primary job. Am I entitled to any severance? I am almost 45.
Well, this person, John, doesn't really sound like an independent contractor, does he? No. He works for a company, does almost all their work for them, full-time hours, gets company equipment to use, etc. This person looks like an employee. And if you look like an employee, you're likely an employee. And it doesn't matter how you pay your taxes. It doesn't matter what you signed that you are. It doesn't matter what the company you work for says that you are. You are likely an employee. Now, I'll take it a step further. There's a likelihood that even if he's not an employee, he's what we call a dependent contractor. Not an independent contractor, but a dependent contractor. And if you're a dependent contractor, you still get severance like a regular employee would. So chances are 99.999 that this person gets their full severance. Same with you. You're likely been misclassified if you think you're an independent contractor. So the last thing for us to do, of course, is, well, let's figure out how much severance this person is owed. We're going to go back one more time for the show today to use the severance calculator at pocketemploymentlawyer.ca. Let's do that right now, and let's see what that gets us. So this person is in a technical role. We know he's an employee. He's been there for 5 years. He's 44 years of age. Severance for him is going to be 8 months pay, 8 months. Because he's not an independent contractor. It doesn't matter what he signed. So you can do the same thing. If you're not sure what you are, call me. And always go to pocketemploymentlawyer.ca to figure out how much you should be getting.
Okay, Leo, let's get to another question. This time we're going to slide over to terminationquestions.com. It's free. It's anonymous for you to use anytime. And for this week, it goes like this. My husband has worked at the same company for 34 years and was recently told to stay home with pay during an investigation. He's in middle management. After a little communication for a week, HR called him in and asked about his retirement plans, saying his leadership style no longer fits the company. What should he do? He's only 55.
Well, it tells me, number one, that this company realized that he did nothing wrong, that they don't have grounds to let him go for cause. That's what they're asking about retirement. If they thought they could let him go for cause, they would have just done that. So the answer here should be, no, I'm not retiring. I'm good to continue working indefinitely. If I ever change my mind, I'll let you know. At that point, if the company wants to let him go, they'll have to pay severance. And by the way, if they do let him go in that situation, that could also be a human rights violation. If they're essentially saying, hey, you're too old, Bob, you should leave, and he says, I'm not leaving, so okay, we're going to let you go, that's illegal. You cannot be let go because of your age. Even if age is a factor, and among several factors in the decision to let you go, that's not legal, okay? Age should not be a factor, and do not resign or say you want to resign unless you're doing it voluntarily. Never do that.
Does the suggestion, hey, what are your retirement plans, Bob? You play golf on the weekends? I mean, isn't the suggestion a little bit risky for an employer?
It is. Certainly it is. And an employer should be very wary to do that. Essentially, you're suggesting to the employee, hey, you're too old for this job, so you really should consider leaving. Now, listen, if it's a one-off-handed comment, I guess you could get away with it. But if it becomes more persistent, you keep being told you should retire or resign, you're being pushed into it, those suggestions keep coming up, that itself can be a human rights violation, all right? So you should tell your employer, I'm not resigning, don't want to hear any more about that. If they keep pushing back on that, that's not legal.
You know, quickly, Lior, in that previous question, you mentioned something about a independent contractor versus dependent. How's the criteria change? Is there a money threshold or a work threshold?
Yeah, so a dependent contractor is someone that's not an employee. They have several customers, but they have one big customer that they do most of their work for, okay? Probably somewhere north of 70% of their work is for one company. Well, they're now a dependent contractor of that company. And if that company decides to let them go, they have to pay severance. So you can actually not be an employee and still get your full severance.
And again, a reminder, pocketemploymentlawyer.ca. There's all this stuff covered, including are you an independent contractor or not? We'll break it down very simply for you. As we get down to the last couple of minutes here, Lior, it is time for Employment Rights Rapid Fire. Strap in. Let's do this. Okay, here we go. Rapid fire questions. I know you love this part, making you sweat a bit, pal. Number one, can an employer let an employee go for any reason?
Generally speaking, yes, your employer can let you go, but for most reasons. You cannot be let go for discriminatory reasons. You cannot be let go because of your age or your sex or your ethnicity. That's illegal. But for any non-discriminatory reason, yes, you can be let go. But of course, John, you have to get your full severance.
And again, pocketemploymentlawyer.ca for that one to find out what that is in the severance calculator. Rapid fire number two, Lior, are employees always entitled to severance pay?
So an employee that's been let go is entitled to severance pay unless they did something terrible, unless they did something so bad that makes it impossible to continue employing them, then that person is owed severance. Remember, you don't get severance if you retire, if you resign. You don't get severance if you got another job and you're taking it. But if the company lets you go, unless you did something terrible, you get your full severance. And that severance, you'll be surprised about how much it is. It certainly can be as much as 24 months' pay.
And that leads us to our next one. Kind of an easy one for you, pal, but does severance pay have a specific calculation?
It does not, okay? It's not a week per year, 2 weeks per year. We look at several factors, including your age, position, and length of employment, and that could be a significant amount. So it's not a straight week per year or anything like that.
Okay, here we go. Can an employee be fired for filing a harassment complaint?
Absolutely not. You're protected if you file a harassment complaint. You cannot be punished, let go. Even if it's determined that there was no harassment, even then you're still protected.
One more to go. Is an employee entitled to the same job when they return from a protected leave?
Correct. If you're on a protected leave of absence, like a parental leave, your job is protected. You have to be hired to the same job, same pay, no matter what.
You got them all in, pal. We're done for the week. We're going to let you fly. In the meantime, here's how to reach out to Lior. 1-855-821-5900. Help at employmentlawyer.ca. And we'll catch you next week on the Employment Law Show.